Hello! In this video, we're going to walk through an independent contractor agreement, and I'm going to highlight some key things that you should keep in mind when you are going through and editing and reviewing your own document. This is not a substitute for legal advice. This is just some quick tips. So if you are ready to execute your agreement, make sure that you have a lawyer in your particular jurisdiction. Give it a once over before you do that. So let's go ahead and talk about this independent contractor agreement. So I'm going to read the preamble just a little bit. This agreement is ideal for companies who hire independent contractors to perform a wide variety of services. So one very important feature of this document is a section that vests the ownership of all copyrights for content created under this agreement with the company. If you are an independent contractor, you may want to revise that section if you want to retain the rights to your work and lease them out, or if you have other means for recurring income from your work. Also, because this agreement is written in favor of the company, contractors who want to use it should go through it very carefully and consider making changes that would be in their best interest. But again, this is a great starting point for any company, but be sure to have an attorney look it over prior to executing. All right, so let's go ahead and just scroll through it a little bit. Now the first part, this is just talking about the date and what day it is. Nothing super important there. Make sure that you take out all of this red verbiage right here, and also before you execute it, make sure you take out the word template and take out all of this red lettering here. Okay, you definitely don't want to submit this to the other party with all of these notes in there. Now, one key thing, and I've talked about this quite a bit if you've seen other videos, is the services that you're going to provide, which is also known as a statement of work, is going to be very, very important. You want to put as much detail into this section as possible. Leave a little bit of detail out if you want to remain flexible, but again, put as much detail in there as you can. Think in your mind what exactly it is you're going to be offering, and then step by step write all of that down in this section here. Very, very important. The term of the agreement, obviously, you want to put that in there. It pretty much speaks for itself. Performance. This right here is just saying that you're basically going to put forth your best efforts to make sure that the contract is going to be performed, to the best of your ability. Currency, that's important if you're going to be doing business with any company outside of the US. And compensation, this is very important as well. Now, one thing you may want to consider putting in here is maybe a kill fee. If you're the contractor and you want to prevent the company from being able to kill this contract without you receiving any sort of payment whatsoever, you put a kill fee in there to say if you terminate it early, then I will be compensated X amount of dollars. That's pretty important. Let's see. So put again as much detail in here in this compensation section as you can. So that right there talks about exactly what I was just describing, which is essentially a kill fee. Reimbursement of expenses. This is pretty common. Usually contractors, independent contractors, are not necessarily going to be reimbursed for regular expenses. However, there might be some, and just make sure you put, detail in this section if there are going to be provisions for reimbursement. This confidentiality section is pretty bare. I would highly recommend expanding this section. There is another confidentiality agreement on the site. You might want to execute a separate agreement and then incorporate that agreement here in this section. However, if you want to keep it in here, you want to keep this verbiage directly in the contract itself. Make sure that you go through and you put as much detail as far as what type of information is going to be confidential and what the obligations are of the parties, both parties probably, in keeping that information confidential. Non-competition. Now this section I don't always recommend companies putting a lot in, because for independent contractors to be considered completely independent, they're going to need to take on additional work, and it's probably going to be with a competitor of some sort. So you don't want the independent contractor to be considered an employee. That's why I generally recommend, not really making this section too detailed. You want to keep it as flexible as possible for your independent contractor so that they will not be deemed as an employee of the company. Non-solicitation is very important because it keeps the independent contractor from poaching employees from the company, and vice versa. It keeps the company from poaching employees from the independent contractor if they do have employees or if they are a full-fledged business. Ownership of materials and intellectual property. This is going to be important for the company, especially if you're hiring the independent contractor to create something or to create intellectual property, work on a trademark for you, or copyright, or create logos, things like that. This section here is going to be very important because it's going to make sure that the interest is fully vested in the company. Return of property, just saying that you have to give the property back once the relationship has ended. And capacity as an independent contractor is just making sure that it is very clear that the individual or the company is working as an independent contractor and is not going to be considered an employee. Notice section, this is important because you want to be able to have an official email address or mailing address where you can send something and it will be deemed as having been received. Indemnification, very important section. I prefer more balanced indemnification clauses. This right here, I actually rewrote this section and it is pretty balanced and it's pretty basic. It's just saying that each party is going to be responsible for their own actions, and they will indemnify, which is another way of saying protect, the other non-acting party from anything that may arise from, the other party's actions. Insurance section, be sure that independent contractors have sufficient insurance, and this section right here just makes sure that that will be the case. Legal expenses, modification of the agreement, those are pretty self-explanatory. Time is of the essence. This is an important clause if there's going to be tight deadlines and or a delivery schedule. Definitely keep this time is of the essence in the contract. Entire agreement. This just says that there are no outstanding oral agreements that are going to be in contradiction to what's written here. And if there are, then what's written in this document is going to be what's going to govern the relationship. Inurement is just saying that the parties that are described here in this document are the ones who will be receiving the benefit. So there really can't be any third-party claims that can arise from this. Titles and headings, pretty self-explanatory. Gender, self-explanatory. Governing law, very important section. So you want to make sure that you put the governing, the state that you want to have the agreement abide by, those laws abide by. You want to make sure you put that here in this section. It's always best, in my opinion, to put the laws of the state that you're currently doing business in. So that way it just makes it a little bit more convenient for you. Severability. So it just says that if one section of this contract is deemed as being unenforceable, then the courts should not throw out the entire contract. They would just remove that portion of it and then keep the rest of it intact. And waiver. This is important because it talks about if one party does not immediately enforce their rights that they're given under this contract, say to terminate or to have some other remedy, then that if they don't automatically enforce that right or send you notification, that doesn't mean that they are giving up the right. That just means that they may enforce it later. That's what the waiver means. That's what this section talks about. And then here are your signatures. right, well, I hope this is helpful. And if you have any questions, please be sure to let us know, and we'll be talking with you very soon.